Good afternoon and welcome to the Chamber of Commerce Southern New Jersey next webinar in a series of events brought to you by Archer & Greiner PC under the umbrella Preparing for the Next Chapter of COVID-19, Legal Guidance for Uncertain Times. My name is Meredith Laura Lear and I am Executive Vice President of the Chamber. Thank you to everyone who has tuned in online to join us today. Before we begin, I must thank our exclusive sponsor of this series, Archer & Greiner PC. Today's webinar is part of a 6-part series brought to you every Thursday from 2 to 3:15 p.m. on what's next as employers start to look at how the pandemic has impacted their operations, their employees, and new considerations as we start to move beyond the pandemic. Today, our legal experts will tackle 2 hot topics. First, Robert Egan and Kate Sherlock will address cybersecurity and data privacy considerations in the COVID age. Then Trevor Cooney will discuss business interruptions insurance coverage issues during COVID-19. A few quick housekeeping items before we begin. In a moment, I'm going to introduce our speakers who will speak on their respective topics, after which we will move to a collective Q&A session. As our presenters speak, the chat function at the bottom of your screen will be open. If you have any questions, please type them into the chat. We will hold all questions until the end of the program, and we will try to get to as many of them as possible before concluding at 3:15 p.m. today. After the event, you will receive a recording of today's program to watch back at your convenience, along with a copy of the presentations from our presenters. Additionally, you will receive a short survey that we would love to hear your feedback on today's program. With those housekeeping items out of the way, let's get started. It is my pleasure to introduce today's presenters. I will start with Robert T. Egan, Esquire. Bob Egan has been a lawyer at Archer since 1977 and is the chairperson of the firm's commercial and business litigation group. Bob has concentrated his practice in business-related litigation in the state and federal courts in New Jersey and in other jurisdictions, with significant experience in complex litigation involving the computer and high technology sectors, intellectual property, copyright and trademark infringement, trade secrets, restrictive employment covenants, franchise, antitrust, and trade regulation, commercial, contract, and class action suits, as well as in cases concerning corporate governance, shareholder, and partner disputes. Bob also serves as chair of Archer's Data, Privacy, and Cybersecurity Group, focusing his practice in the area of cybersecurity, counseling, and data breach response. Thank you for being here, Bob. Joining Bob is Kate A. Sherlock, Esquire. Kate collaborates with clients to protect their intellectual property rights and data. She represents clients of all sizes across most major industry sectors, including the automotive, clothing, entertainment, healthcare, and tech industries. As a member of Archer's Data Privacy Group, Kate helps clients comply with various data privacy laws, including the California Consumer Privacy Act and the General Data Protection Regulation. She reviews third-party vendor contracts and service level agreements and drafts both internal and outward-facing policies and procedures governing data privacy and cybersecurity, including privacy policies and cookie notices. Thank you for joining us, Kate. Now allow me to turn the program over to Bob and Kate to kick things off. Bob?
Thank you, Meredith. So folks, thanks for joining. We hope to tell you a good bit about what's happening in the cyberspace dealing with COVID-related things, but we're also going to tell you some things about cyber in general. We hope you find our presentation to be helpful and informative. But we had a lot to discuss in a short period, and we'll try to get you out of here so you can watch today's episode of Ellen. The first question is, why are we talking about cybersecurity and data privacy issues in the context of COVID-19? But before we get there, I want to be sure that we get across 3 main recommendations, which we're going to repeat throughout our presentation, and which apply kind of generally to cyber, not just to COVID. The first is pay attention to all cyber risks and how you defend against them. Secondly, to do that, retain professionals who are experienced in cybersecurity and data privacy in the areas of IT, cybersecurity planning, forensic investigations, and law. And the third point is get cyber insurance. In that area, one size does not fit all, and you can't just buy a cyber policy off the shelf. So when you look for cyber insurance, and please do, be sure to use an experienced broker. So those are the three main things that if you get nothing out of this program on cybersecurity and data privacy, that's what you should take away. Next slide, please. So kind of returning to the actual topic, what does COVID have to do with cybersecurity and data privacy? Well, since the spring of 2020, there's been a huge uptick in COVID-related cyber schemes and cyber scams. And it's not slowing down at all. And in fact, technical experts in this area and government authorities have described it as a cyber pandemic. So what's going on is that hackers leverage the fear, uncertainty, and doubt that surround the global health crisis in order to basically suck people in. You know, people are on edge in any crisis. They want information, they want to know how to protect themselves and how to protect their families. And they look for direction from their employers, from government agencies and other relevant authorities. For example, an email that you get that appears to be from one of these entities and either promises new information or instructs a recipient that they must complete a task quickly is likely going to receive less scrutiny now than it would have prior to the crisis. And in addition, working from home increases cyber vulnerabilities significantly. You know, there's more distractions at home than in the office. In fact, I can hear my dog barking upstairs. I hope it's not bothering anybody. And there's also more computer endpoints to attack. And workers store their employers' information on home computers, which often don't have up-to-date cybersecurity tools in order to ward off an attack, such as up-to-date antivirus software and secure firewalls. So our objective today is to give you an overview of these issues and tell you of some things that you should do in order to protect your business. Next slide, please. So what's happening is that cyber criminals are leveraging tried and true data breach scams to obtain confidential information and to introduce malware into computer systems. And there are a few common types and common ways in which they do that. Next slide, please. The first is phishing, which is a practice of sending fraudulent communications that look like they're coming from a reputable source, usually done through email, but it can also be texts, IMs, or phone calls. And the goals are to get the victim to provide information that's valuable to the fraudster. Either the fraudster will use it or sell it. That includes things like login information, credit card information, social security numbers, banking information, and the like. Another goal is to get the victims to click on a link, which will in turn install malware on the victim's machine, and then depending upon what it's hooked to, can spread that malware to the network. Spoofing is phishing, but from a known trusted source. So an example might be a text or an email from a hacker that appears to be from the CEO or the CFO or a customer, and it commonly tells the recipients, often in the accounting departments, to wire a payment to an account and do so in a hurry. They often use official logos and header images that make the email look real. Excuse me, next slide, please. So another common attack vector is what they call a malicious domain attack. And there, a malware is introduced into a system through a malicious website, often again by clicking on links that are found in emails or texts. Now, for those who have not encountered malware before, it's software that performs malicious actions on a device, and various types of malware have different capabilities, such as stealing confidential information that's found on a computer system, which can be personal information of employers or customers, which is called in the cyber trade personally identifiable information, or health-related information or login information. Another thing it might do is provide remote access to a system that actually allow hackers to take over a system. Sometimes they lie in wait for months before they actually spring and issue commands on the system, such as the one I mentioned before, in which an email is sent instructing accounting to pay a vendor quickly. But these are actually coming from the email account of the CEO or a customer because they've taken it over. The hackers have taken it over. And these are called business email compromises or CEO frauds. Malware may also alter data in the system or destroy files in the system. And the most common type of malware these days that cyber criminals use is called ransomware. And you may be familiar with that, but ransomware locks up a system by encrypting files, and it renders them unusable. And the threat actors then demand a ransom in exchange for a promise of decryption. The ransom is often paid in cryptocurrency, and sometimes they don't come through with the decryption. They just promise it and then just take your money and go. Next slide, please. So those are the kind of the common ways in which scammers steal things. And how does this apply to the COVID world? Well, in the COVID world, scammers apply them to the COVID-related vulnerabilities that we mentioned before. And some common examples are cyber criminals send emails or texts and sometimes make phone calls, again, to fool users into providing information or clicking on links. Several common ones these days are vaccine related. Some senders pose as the government entity, some don't. It poses something else. Some offer appointments for vaccines or offer to jump the line, to provide potential victims with appointments that are sooner than they're actually permitted. Some pose as contact tracers. And in one example read something like, you've been identified as someone who has been in contact with a person who tested positive for COVID-19. Others offer to tell you who in your neighborhood has tested positive, so presumably you'll know to stay away from them. But again, they're phony and they ask you to click on links and to provide information. Others that I've seen have posed as a government and offer information or services regarding stimulus checks. We've also seen emails from the CDC or the World Health Organization about health risks and threats. A lot of them offer miracle cures or critically important health information. And similarly, emails come purportedly from the UN regarding small business relief, and others take advantage of the PPP program. Some emails contain contain ads that offer vaccines and miracle cures, or ads soliciting donations to fake charities, or ads for COVID testing kits that you pay for, but they're never going to come. So why do these things work? Well, a lot of reasons. One is that people use weak passwords, and employers don't have adequate password policies. In fact, could you move to the next slide, please? And passwords are like vulnerable to what is called a brute force attack, which is a hack in which computer programs use to guess possible combinations of a targeted password until the correct password is discovered. It's like automated. So for example, if your password is your mother's maiden name, which is fairly short, plus let's say 3 numbers, the program's just going to go through all those possible combinations, and eventually they're going to guess the correct password. These schemes also work because of technical and technological vulnerabilities that allow the malware we mentioned to enter the back door of your computer systems, often due to inadequate security patching. The IT people, and we've seen it in data breach matters that we've handled. IT people don't keep up to date with the latest security patches that software developers offer. Devices are often not properly configured to ward off malware, and there are a significant number of user errors. And with specific reference to COVID, these schemes trick people into breaking what would be standard security practices that we would use and do use when we were back in the office, because of the employees, people's normal anxieties over the pandemic in general. And it's also because of a lack of adequate employee training in cyber awareness. So that's kind of the background. So let me turn it over to Kate. And with all that going on, Kate, what's the relevant law and what are the legal risks to businesses?
Sure, thanks, Bob. Next slide, please. So currently in the United States, unfortunately, we don't have a single federal law that directly imposes any sort of security obligations across all industries. Instead, what we have is a patchwork of state laws and industry-specific regulations like HIPAA, which governs the healthcare industry, and Gramm-Leach-Bliley, which governs the financial industry. So it's worth noting for purposes of today's COVID presentation that there's no specific law that relates directly to the collection of COVID-related information. And when I say COVID information, I mean things like your employee's temperature that you're taking every day when they come to the office, information about whether your employees have tested positive for COVID, whether they've been exposed to COVID. To the extent that you are collecting that information, you're going to be subject to existing data privacy laws. So if you're a covered entity under HIPAA, HIPAA is going to govern your collection of that information. Now, if you're not subject to HIPAA, you're still likely required to keep that information confidential under a different applicable law like the Americans with Disabilities Act. And that's really more of a labor and employment issue. I'm not going to go much further into it today, but it's my understanding that some of our colleagues at Archer touched on this issue at a prior webinar in this series, but I thought it was worth mentioning. Next slide, please. So currently in the US, all 50 states, DC, Puerto Rico, and the US Virgin Islands, they all have their own state breach notification laws. And these are the laws that come into play after a business is breached. It imposes certain obligations on businesses for notifying affected individuals. Now you may be thinking, I'm a New Jersey business owner. I'm at the South Jersey Chamber of Commerce webinar. Why do I care about any law other than New Jersey's data breach notification law? And I'm here to tell you, we have to care because unless one of the industry-specific laws applies, like HIPAA, generally it's the law of the state in which the individual affected by the breach resides, which governs. So in other words, if you're a business owner and you suffer a data breach and you hold the personal information of people residing in 30 different states, you are generally required to comply with 30 different data breach notification laws, which can be a compliance nightmare if you're not prepared. Next slide, please. To further complicate things, some of the states have gone a little bit further than just simply imposing data breach notification obligations. Some state laws directly require businesses to implement security controls to prevent data breaches. New York is one of those states. They passed the SHIELD Act recently, and that law requires any person or business with computerized data of private information of a resident of New York to implement and maintain reasonable safeguards to protect the security and confidentiality of that private information. Next slide, please. Now, the law in this area is changing rapidly. We've definitely seen a national trend among the states passing laws that increase the obligations on businesses to implement these reasonable security measures and to provide individuals with greater control over their data. California currently has the most comprehensive privacy and security law in the United States, called the California Consumer Privacy Act, or the CCPA, and I'm going to discuss it a little bit later in this presentation. But we're also seeing this trend in the courts as well. Just generally, they're imposing obligations on businesses to implement these reasonable measures to protect information. And unfortunately, there is no list of what constitutes a reasonable measure. The cases are determined on a case-by-case basis. And the one thing we do know at this point is that doing nothing is certainly not reasonable under the law as it exists today. Next slide, please. So I'm not going to tell you about all of the different state breach notification laws and the differences among them. We will be here until March if I did that. But what I am going to tell you is I'm going to go over some of the main issues that these laws address, and I'll throw in some examples of the variation among the states as we go along. So first up, the state breach notification laws are going to define personal information. They're going to tell you what information is subject to the data breach notification obligation. And a few examples of personal information under most state laws are someone's name plus their social security number, someone's name plus their bank account number, and more recently now, someone's email address or their online account username plus their password, or an answer to a security question such that someone would be able to gain access to their online account. The state laws also will identify what type of entities are covered by the data breach notification law. A lot of the laws require businesses to be doing business in the state to be covered. Some of the laws, some of the states like Georgia have a little bit of a more narrow definition. The state laws are also going to define what constitutes a security breach that triggers the notification obligations under the law. Now in New Jersey, if personal unencrypted information is accessed by an unauthorized person, that constitutes a security breach. Technically, the hacker doesn't need to acquire the information or copy it or exfiltrate it. Access is enough in New Jersey to trigger that notification obligation. Next slide, please. The state laws are also going to define the level of harm required to trigger those notification obligations. So, for example, again, in New Jersey, notice is not required if the business or the public entity can establish that misuse of the information is not reasonably possible. Now, if your business makes this determination, you need to document it in writing as to why it's unlikely, and you need to preserve that documentation for at least 5 years. The laws are also going to provide guidance on who you need to notify, when you need to notify them, what to include in your notification letter to affected individuals, and how to make that notification. The state laws vary on when to notify, and it's important to understand that when you discover a security breach, the clock starts ticking. So in New Jersey, the standard is you need to effect notice on affected individuals in the most expedient time possible and without unreasonable delay. Some of the other states set a time limit. They say no later than 45 days after the breach is discovered. Puerto Rico has the quickest turnaround. You have to notify the Department of Consumer Affairs within 10 days of discovering a breach. Experts in the field recommend that as a best practice for companies that are operating nationally is to make notice within 30 days after first discovering a data breach. So time is of the essence. Next slide, please. The state breach notification laws will also indicate whether or not you are required to notify the state attorney general or some other state agency. 2/3 of the states have a requirement like this. In fact, in New Jersey, prior to sending notification to affected individuals, you must notify the Division of State Police and the Department of Law and Public Safety before you send those letters to the individuals. The laws will also provide guidance on when notification to credit reporting agencies is required. Again, in New Jersey, the threshold is 1,000 state residents. So if the data breach affects more than 1,000 people, you are also obligated to notify national credit reporting agencies of the breach. Now, like all laws in the United States, most of these data breach notification laws have exceptions. Two of the more common exceptions are for data that is encrypted, redacted, unreadable, or otherwise unusable. And the reason for this sort of safe harbor is that if the data is encrypted, harm is unlikely to come by someone merely accessing encrypted data. Now, if the hacker gets access to the encryption key, that safe harbor goes out the window. There's also an exception for companies that are subject to a more stringent data privacy law, some of the industry-specific laws that I mentioned earlier. So if you're a covered entity under HIPAA and you're required to comply with HIPAA's data breach notification obligations, you're not then also required to comply with the state laws, their data breach notification laws. And finally, all of these state breach laws will also address penalties. Most of the states reserve enforcement to the state attorney general. Some of the laws also grant a private right of action to affected individuals. For example, the California Consumer Privacy Act grants a private right of action to consumers for certain types of breaches, and they're actually allowed to recover statutory damages, which means they don't have to prove their actual damages, statutory damages of $100 to $750 per incident, which can add up pretty quickly if you have a significant data breach. Next slide, please. So speaking of the CCPA, this is by far the most far-reaching data privacy and security law in the United States right now. It went into effect on January 1, 2020. And actually this past November, California residents voted yes on Prop 24, which amended the CCPA and passed the CPRA, which sort of expanded some of the obligations under the CPA, but that doesn't go into effect until 2023. So for purposes of our discussion today, we're going to focus on just the CCPA. Now, this law has extraterritorial application. And what that means is that you don't necessarily need to have a physical presence or a location in California to be subject to this law. The CCPA applies to any business that collects California consumer or residents' personal information that either has annual revenues of over 25 million, annually buys, receives, sells, or shares personal information of more than 50,000 consumers, households, or devices, or derives more than 50% of your annual revenue from the sale of consumer personal information. Now, you may be thinking, I'm a small business. I don't have anywhere near 25 million in annual revenue. This doesn't apply to me. But you may want to take a second look at that second requirement there, the buying, receiving, selling, or sharing personal information, because under the CCPA, personal information is defined very broadly. Next slide, please. This is not the personal information that I mentioned earlier that constitutes someone's name and social security number. We're talking about a much broader scope of potential information here. The definition is any information that identifies, relates to, describes, is capable of being associated with, or could reasonably be linked directly or indirectly with a particular consumer or household. So what does that mean? Well, some examples of personal information under the CCPA include an IP address, a driver's license number, religion, race, sexual orientation, national origin, internet and browsing history. So if you have a website with cookies and you're collecting information about visitors to your website, you're likely collecting personal information of California consumers as that term is defined under the CCPA. Now, this law goes beyond simple breach notification obligations. It also imposes additional obligations onto businesses. You have to make certain disclosures to your customers. You have to tell them what categories of personal information you're collecting about them. You have to tell them why you're collecting the information, what purpose you're using it for, how you're using it, whether you're disclosing it to anyone, and how long you're keeping that information. The CCPA also grants California consumers certain rights over their information. Next slide, please. For example, California consumers have the right to request what information has been collected about them. They have the right to request that you delete their information. They also have the right to opt out of the sale of their personal information. And this is why when you visit a website nowadays and you scroll down to the bottom of the screen where the legal notices are, I don't know if you do this, I certainly do this as a privacy attorney, but you'll notice at the bottom of the screen, there's typically a link that says California rights or do not sell my information. And the reason for that disclosure and that link is because of the CCPA. Now, interestingly, while the CCPA only grants these rights to California consumers, some businesses are opting simply to apply the CCPA standard across the board for all of their customers. And the reason they're doing that is because it's difficult to apply one set of standards to customers living in California and to apply a different set of standards to all of your other customers. So they're just sort of, taking the CCPA as the most stringent law and applying it totally across the board. So this law has really had a serious impact on data privacy over the last 2 years. Next slide, please. In addition to your potential data breach notification obligations under state and federal laws, you may also have certain obligations under contractual agreements with third parties. I encourage you to take a look at your contractual agreements that you have with your suppliers and your vendors to see whether or not you have agreed to certain data breach notification obligations or other cybersecurity obligations via these contracts. And conversely, you want to make sure that to the extent your company is subject to any specific disclosure requirements, like the disclosure requirements of the CCPA, that you're flowing those obligations down to your vendors and your third-party partners. And this is actually mandatory under some of the state data breach notification laws. I want to remind you, you're only as secure as your least secure vendor. If you remember the Target data breach that happened back in 2013 around Christmas time, I think it impacted something like 70 million Target customers. It wasn't a result of a direct breach on Target. What happened was the hackers sent a phishing email to one of Target's vendors, an HVAC refrigeration company. An employee at the HVAC company clicked on the phishing email. The hackers got access to the HVAC company, and then they were able to gain backdoor access to Target's network via that breach. And I think it cost Target something like $300 million. So it's really important to vet your vendors, to impose, data privacy and security obligations onto them, and to make sure you address indemnification and liability issues. You don't want to be stuck holding the bag as a result of a data breach that happened because your vendor didn't use encryption and didn't have a password policy. So double check your agreements. Next slide, please. All right, that brings us to consequences. So you're probably wondering, what happens if I don't send the notifications that I'm required to send under these state laws? Well, you could be facing statutory fines and penalties imposed by the government. For example, New York Shield has a $20 per instance of failed notification, and that's capped at $250K, and up to $5,000 per violation with no cap for certain failures for failure to comply with those new data security standards that they passed under the New York Shield Act. You could also face damages from litigation. CCPA creates a private right of action for affected individuals to sue for statutory damages. And in fact, in New Jersey, a willful, knowing, and reckless violation of the data breach law is a violation of the Consumer Fraud Act. And affected individuals can sue companies that were subject of a breach if they willfully, knowingly, and recklessly breach the data breach notification law. So there's quite a few penalties and fines that you could face, and they would add up very quickly in the event of a large-scale data breach. So that's basically an overview of the legal landscape. I'm going to turn it back over to Bob to tell us about some of the practical risks and consequences of a data breach and what businesses can do about them.
Thanks, Kate. One of the things about webinars is sometimes we think we can cover things in a much shorter period of time, but it turns out we can't. And we have our colleague Trevor standing by to talk about insurance, which is also obviously an important subject in the context of COVID. So let me wrap up the cybersecurity and data privacy portion of this by saying, almost as I began, what's happened with COVID is that it is identifying new types of threats, and we have this obligation as businesses to plan to deal with unwanted intrusions and protect people's information for a variety of reasons. And COVID is just kind of another route. A lot of what we've told you so far can apply and does apply to data breaches from threats regardless of the subject matter. The rest of our PowerPoint deck that you'll be getting contains some, I think, practical advice as to what you can do and should do, and I would say need to do in order to protect yourselves and minimize those risks. I'd urge you to, if you've made it this far through the presentation, I'd urge you to read the remainder of the slide deck. And at the end of the slide deck, there are sites to, I think, four right there, four what I call helpful resources that contain a lot more specific information about all of this. But I'll leave you where I started. Don't try to do this yourself. You have to hire people from a variety of professions to walk you through all this, to make the best judgments that you can, which are often scalable to your expenses and your budget in order to best protect yourself and minimize the risks. If your doctor, if your surgeon handed you a scalpel and said, go operate on yourself, you wouldn't do it. If you needed open heart surgery and your internal medicine doctor or your GP said they were going to do it, you wouldn't let them to do it. Hire people, retain people who know what they're doing in this area. And with that, I'll turn it back to Meredith.
Thank you so much, Bob and Kate. I just want to remind everybody in our audience that you could submit your questions in the chat for Bob, Kate, and Trevor, and we will get to as many as we can following the presentation. With that, I would like to introduce our next speaker, Trevor L. Cooney, Esquire. Trevor helps companies successfully navigate the arena of complex business litigation, including intellectual property and technology-related disputes, claims under the Uniform Commercial Code, consumer protection and unfair business practices actions, consumer class actions, and real estate matters. As head of Archer's Insurance Practice Group, Trevor regularly counsels and represents policyholders pursuing insurance coverage under a broad array of first-party and third-party policies, including commercial general liability, errors and omissions, directors and officers liability, business owners' commercial property, inland marine, homeowners, life insurance, and disability policies. Trevor, thank you for being here today. I turn the floor over to you.
Thank you, Meredith, and thanks for inviting us to participate here today. I'm glad to see that Kate and Bob made it through their presentation without any cat filters popping up in their faces. That's a success for them. I'm hoping I can make it through unscathed as well. A couple preliminary points. I am, as Meredith indicated, a policyholder attorney. So although I'm going to present two sides of the arguments today, one pro policyholder, one pro insurer, the fervor by which I present the insured side, the policyholder side, will be much greater than the insurance company side, and you'll see that in some of my slides here today. But I think this audience will be okay with that, given we're mostly business owners. And secondly, in the limited time we have, we can't dig into a lot of the minutia of policy terms and conditions, which is often what you need to do as a policyholder attorney to fight for coverage. But we are going to touch on some of the most important terms and conditions as they relate to business interruption. Next slide, please. So here's a guidepost on what we're going to cover here today. A quick primer on what business insurance coverage or business interruption insurance coverage is. What does it cover? What triggers the coverage? When should I submit a claim? And hopefully by now you have already done so, as there are restrictions in the policies, which we will talk about. What if my insurance company did deny coverage? You can be sure they did in this case, as they universally denied coverage across the board. Update on the status of coverage litigation in the US today, both in the state and federal courts. What arguments have been successful, which ones have not, and why? And then importantly, at the end, approaching deadlines by which you have to file suit against your insurance company if you're going to. So with that, let's go to the next slide. Okay, we have to revisit 2020. I know it's painful and we don't want to go back there necessarily, but it has to set the stage, helps to set the stage for today. So early in 2020, coronavirus hits the US and starts spreading. The World Health Organization releases white papers, informational guides on how it is spread. In this case, person to person via airborne droplets, mostly through breath, coughing, sneezing, etc. The CDC quickly releases guidelines on how to clean and disinfect surfaces because there was some guidance that came out that the coronavirus could survive on hard surfaces for 24, 48, 72 hours. All we knew is that there was a lot of uncertainty, but the virus was spreading quickly. Next slide, please. So our various government leaders felt obligated to take steps to certainly mitigate the spread as much as possible. Various executive orders were issued by both Governor Murphy in New Jersey and governors around the country. The one that's most pertinent to today's discussion is the March 21 Executive Order number 107, which required that all brick and mortar premises of all non-essential retail businesses had to close to the public. Obviously, this was done to mitigate the spread of virus, but had huge effects on our businesses. Next slide, please. These entities, these non-essential businesses, complied with their obligations, shuttered their doors, or at least severely limited their operations. Retail stores, restaurants, and other customer-facing businesses were hit the hardest. Restaurants were allowed at one point to proceed with takeout orders, delivery and the like, but not in-room dining, in restaurant dining, which had catastrophic effects on many businesses. Certainly a multi-billion-dollar issue across the country, businesses around the country and around the world. So these businesses obviously looked for ways to recoup as many of those losses as they could. There were government programs like the PPP loans that served a purpose, helped people back on their feet, but certainly didn't make them whole by any stretch of the imagination. So these businesses look to their attorneys, their brokers. Hey, didn't I buy an insurance policy that might be responsive to this type of loss? Didn't I buy business interruption coverage in my business owner's property policy and my commercial property policy? Next slide, please. So this is, there are many different forms of business interruption coverage in various policies. This is an example of one. Business interruption coverage provides coverage for the actual loss of business income due to the suspension of your operations caused by physical loss or damage to covered property. And sometimes that highlighted language reads physical loss of or damage to covered property. And I highlight that language in particular because that is the principal key language that the policyholders, insurance companies are fighting about. Next slide, please. Okay, relatedly, there's a coverage called civil authority coverage. It's similar in nature. This is another example of a type of civil authority form you might find in your policy. It covers loss of business income sustained when access to your insured property is prohibited by order of a civil authority as a result of direct physical loss or damage to properties adjacent to the insured property. So business interruption is damage to your property. Civil authority is damage to property around your property, but there is a civil order issued that prohibits access to yours. And the question becomes, did the governors here shut down orders from March 2020? Were those the type of orders that would have triggered this type of coverage and for the benefit of the policyholders? Next slide, please. Okay, what happened next? Very early on, as the pandemic grew, the insurance company got out ahead of the messaging, issued preemptive press releases saying, Now, we don't cover pandemic-related losses, so there's just not going to be any coverage for you, even before claims started to roll in. And those who called their insurance companies before filing or without filing a claim, that was the response they were often met with. Some brokers who were, I guess, uninformed and maybe not willing to fight as hard for their insureds had the same messaging to their clients. I was approached by many insureds who told me that's what their professionals told them. And unfortunately, this had the effect of dissuading many policyholders from even filing claims with their insurance companies. And that's significant because there are, in just about all, if not all, insurance policies, time elements for when you need to submit a claim. Often it's immediately or as soon as practicable. There's also a similar time requirement for filing a proof of claim. That's the document by which you sign, I've suffered X amount of dollars in loss. Here's the proof that supports that. Those often have to be submitted as soon as practicable. Next slide, please. So thankfully, not everyone listened to the insurance company's rhetoric, and thousands, if not, heck, it might be a million now, a million or more businesses did file claims with their insurance companies. And that's important. Why? Because you have to be in the fight to win the fight. If you don't file claims, if you don't get the coverage decisions from your insurance company, you may not be able to gain the benefit of any successes down the road that other policyholders have had in the court system. As I've mentioned before, the insurance companies, when they did receive these claims, almost universally denied coverage, often without investigation. And the two principal bases they set forth for denying coverage is one, that the presence of the coronavirus itself wasn't enough to satisfy this physical damage or physical damage or loss to covered property requirement that's in every policy. And secondly, there is several of these, or many of these policies had what they called a virus exclusion in the policy. Next slide. Again, virus exclusions are wide and varied, have different forms. This is an example of one. To take a step back, this virus exclusion was introduced in or around 2006 in response to the SARS and bird flu outbreaks. This is an example of one that you will find in many insurance policies, property policies. We will not pay for loss or damage caused by or resulting from any virus, bacterium, other microorganism, etc. And obviously, I'll highlight the word virus because the insurance companies have said this is a coronavirus. It must naturally fall within the context of this exclusion. But there are certainly other forms that talk about pollutants and contaminants as opposed to the language before you. Next slide, please. So since the pandemic has hit, there have been over 1,000 declaratory judgment lawsuits filed in state and federal courts around the country, mostly by policyholders, but certainly some by the insurance companies. And this is the mechanism by which one of the parties can ask the judge to make a determination on coverage. If it's the policyholder, they say, Judge, I was denied coverage. I think they wrongfully denied me. I'm asking you to analyze the issues, apply to the lots of the facts of the case and the policy language within my policy, and tell me if there's coverage. There's a great website being maintained by the University of Pennsylvania Law School called the COVID Coverage Litigation Tracker. It has done an excellent job updating and maintaining this database that shows the summaries of the court rulings to date. Next page, or next slide, please. As I said, there's more decisions coming out every day, but there's been approximately 180 to 190 that I'm aware of to date. And admittedly, the insurance companies have been successful in the vast majority of them. In 140 plus cases, the insurance company has been able to gain a dismissal of the complaint in dismissing the policyholder's case entirely. In about 30 plus cases, the policyholder has either survived what they call an initial motion to dismiss. Doesn't mean they've succeeded in full yet, but they're being allowed by the court to proceed with discovery and proving their case. And in certain circumstances, there have been outright victories where the court grants what they call summary judgment in favor of the policyholder, meaning there has been a finding of coverage in favor of the policyholder. A couple caveats to that, obviously, that these are, to this point, trial court decisions. So it's most of the losses, certainly all the losses by the insurance companies are on appeal now, and there's been briefing and arguments in some of those cases, but not yet any decisions that I'm aware of. And certainly many policyholders who have lost at the trial court level are appealing to the appellate division as well. So we have to see this work its way through the appellate division level or the Supreme Court level, because as I noted in the last point here on this slide, these decisions are state specific. So a court may have issued a holding in an Idaho coverage litigation related to COVID-19, but it doesn't necessarily, or it doesn't have any precedential or binding impact on what the New Jersey courts do. They can look for them for guidance. They may deem them persuasive, but certainly not controlling. So for the purposes of our audience here today, certainly the New Jersey court system is key to how that proceeds. Next slide, please. So I wanted to go through a few decisions on either side of the coin. One, a few pro-insurer, a few policyholder, pro-policyholder. The first here is this Michigan decision from a Michigan state court in Gavrildes Management Company versus Michigan Insurance Company. This is an example of when a Michigan cafe owner sought coverage for losses attributable to the governor's shutdown orders in Michigan. In this case, the Michigan court found that the policy was clear and ambiguous with respect, particularly with respect to the phrase physical loss or damage. It said it must be something with material existence, something that is tangible, or, and this is often a key one in these cases, alters the physical integrity of the property. It's not enough for a virus to be present. It has to affect some change onto the covered property. And here the court found that the complaint didn't even allege physical loss or damage to the restaurants. It was merely alleging that the loss of business was due to the executive orders that shut down the in-restaurant dining. In fact, the complaint here had conceded that COVID-19 itself had never entered the restaurant premises. So that's an example of a loss for policyholders, victory for insurance companies. Next slide. This is a very similar case, Roses One LLC. It's a District of Columbia case where a restaurant group or group of restaurants sought coverage for, again, lost income caused by the executive orders that restricted use of their properties for dine-in restaurants only. The court heard similar arguments, but rejected the policyholders' arguments and held that, again, orders themselves did not affect any direct changes to the properties. Plaintiffs offered no evidence that COVID was physically present in their restaurants when they were forced to close. And just basically, the mayor's orders were not enough to satisfy physical loss or damage. Next slide, please. Okay, this one deals with the virus exclusion I mentioned, right? So this is actually a New Jersey law division case right here in Camden County that was pro insurance company. I put before here on this slide the virus exclusion that was at issue in this case. It barred coverage for loss or damage caused directly or indirectly by any virus, bacterium, other microorganism. This is similar to the one I showed earlier. Significant to this case, though, is that it also contained a provision that's called an anti-concurrent causation provision, which basically excludes coverage for, in this case, a virus, whether it was the first cause in a sequence of loss or the last cause. If a virus appears anywhere in the sequence of loss, it's enough to fall within the exclusion and bar coverage. And that's exactly what the court found here. The complaint identified coronavirus as being the basis for the governors issuing their shutdown orders. And so given the presence of the anti-concurrent causation provision in the exclusion, the virus is a cause in the sequence of loss and therefore had to bar coverage. Next slide, please. And I should say just yesterday, I didn't have an opportunity to include it in my slides, but just yesterday, a federal district court in New Jersey in the I-Center versus Twin City Fire case held the same as the state court, held that the virus exclusion applied to bar coverage there because but for the spread of the COVID-19 virus, the executive orders would not have been issued. Again, that's the insurance company's views, and some courts have picked up on it. I don't necessarily endorse, or I certainly don't endorse that view. Here's another pro policyholder decision. This is one of the early ones. It's a North Carolina decision. Again, restaurants shuttered by civil authority closure orders. And this court, in construing that physical loss requirement, said if you only construe physical loss to mean actual physical alteration to property, it would conflate the phrases physical loss with physical damage. And that can't be the case because it would render one of those terms meaningless. So in other words, if you're going to include two phrases, physical loss and physical damage, they must necessarily mean different things. Otherwise, the insurance company wouldn't have put both phrases in it. And in this case, what was great about this decision is that the court actually granted summary judgment in favor of the insured here, said this is precisely the loss that was covered by the government's orders because they lost the use of their restaurant for the purpose for which it was insured, purpose of why it was operating. Next slide, please. Okay, this is a district court case, federal court case out of Missouri, Studio 417. Interestingly, and I raised this case because in this situation, the plaintiffs actually alleged, the hair salon plaintiffs actually alleged that their premises had likely been infected by COVID-19. So unlike some of the earlier cases that went pro-insurer, where the court said they didn't even plead, the plaintiffs didn't even plead the presence of the virus on their premises, here they went out of their way to plead it in their complaint and said this means they suffered a direct physical loss. The insurers again argued that policies were only designed to cover tangible physical loss. Often the example they often throw out there is caused by a fire. But the federal court disagreed and denied the insurer's motion to dismiss. In this instance, and in most instances, frankly, the policies do not define those phrases, direct physical loss. And in that instance, under New Jersey law and other law, in this instance, Missouri, you have to look to the plain meaning, which means the dictionary definitions of in most instances. Next slide, please. These are the dictionary definitions that the court in Studio 417 looked at. And again, they noted the distinction between physical loss and damage, right? Here, the policies provide coverage for accidental physical loss or accidental physical damage. The defendants are trying to conflate those terms. However, I, as the court, must give both terms meaning. Next slide, please. Okay, this was one of the first business interruption decisions in New Jersey that was related to the executive orders. And this was another, I think it's a Bergen County decision, Bergen County Law Division. And the court denied the insurance company's motion to dismiss. And importantly, as I mentioned before, both sides had cited to out-of-state precedent, including cases that were recently decided on COVID-19 issues. The judge said, I wasn't interested. I'm not interested in those. This is decided under New Jersey law. You must point me to the New Jersey law that exists on the issue, or otherwise it's a new issue for the court to decide fresh. And the court said that FMI, the insurance company here, was unable to present controlling authority for its position that the closure of the plaintiff's business does not qualify as a direct physical loss. Next slide. To the contrary, there had been a great decision for policyholders back in 2019. It was an appellate division case, so it's binding on the trial court judges and courts around New Jersey. And it wasn't a business interruption case, but it did address the issue of what qualifies as physical damage or loss. And it said, looking at the definition of physical, since it can mean more than the material alteration or damage, it's incumbent on the insurer to make this clarification in the policy. And failure to do so here made the result that the court allowed the policyholder to at least proceed with its case, take discovery on this core issue. Didn't rule ultimately in favor of the court yet, of the policyholder yet. That's still to be decided. One other important note about this case, though, is that the policy at issue did actually have a virus exclusion in it, but the insurance company's attorney elected not to try to invoke that exclusion because there was no allegation in the complaint that the premises had been, that the virus had infiltrated the premises. Unlike other insurance company attorneys around the country and in other cases where they say, it doesn't matter where the virus is, if the loss is based in any way on the virus, it has to be excluded by this provision. Here they're saying it only applies if the virus in the first instance is present in the insured premises. Next slide, please. And this is the last case we'll discuss here today. This is dealing with the virus exclusion that came down in favor of the policyholder. Unlike some of the exclusions we've looked at earlier, this one applied to loss caused by fungi, wet rot, dry rot, bacteria, and virus. And the court felt that this was an important distinction from, unlike the prior versions of the exclusion we saw, COVID-19 did not logically align with the grouping of the virus exclusions with these other pollutants. What does COVID-19 have to do with fungi or wet rot or dry rot or bacteria? And so for that reason alone, the court said that the insurance company had not met its burden of showing that the virus exclusion applied. Next slide, please. So I know I'm running short on time, so I'll be quick here. Here are the takeaways for today's purposes. Number one, first and foremost, never accept the insurance company's declination letter at face value. Please have it reviewed by a competent attorney who deals with insurance coverage issues. Certainly at least have it reviewed by your broker who can guide you in the right direction. Because as you saw here today, policy forms vary so much, and it's critically important to make sure or to see what form you have. Here are the arguments, right? We've touched on these. You cannot conflate physical loss with physical damage. Loss of use of your premises for its intended purpose is enough to satisfy physical loss. Relatedly, physical damage or loss, if those terms are undefined in the policy, they must be deemed ambiguous because they're susceptible to two different reasonable interpretations, and they must be construed against the insurance company. Next slide, please. Where possible, again, you can't file frivolous lawsuits or unsupported lawsuits, but where possible, assert that the coronavirus physically was present on your insured premises. Certainly, especially so if there's no virus exclusion. As I mentioned, numerous courts around the country have denied coverage on this basis alone for failure to plead that physical loss as a result of the coronavirus. If there is a virus exclusion in your policy, which version is it, right? It's important, as we saw, it's important which version, if any, you have in your policy. It may not apply at all, depending on the wording of that exclusion. And just as importantly, is there an anti-concurrent causation provision? If there isn't, under the New Jersey law, there's something called the efficient proximate cause doctrine that says if there's a covered loss anywhere in the sequence and there's no anti-concurrent causation provision present, that means as long as one of those losses in the chain is a covered loss, then the coverage should be provided. So in this instance, the first cause in the chain of causation here is the coronavirus. The executive orders were issued because of the presence of the coronavirus, but there's no exclusion that applies to the issuance of the executive orders themselves. And then lastly, as I mentioned, we're coming, next slide, please. We're coming close to the 1-year anniversary of these executive orders being issued. Why is that important? Because just about every one of these policies will have some sort of suit limitation provision in them. Different than a statute of limitations. It's a provision that says you, the policyholder, must file suit within one year or 2 years of a certain date, often the date of the loss or date of damage. And these are generally found to be enforceable around the country. Some states, including New Jersey, have different law or different rules on the tolling of deadlines while the insurance company is adjusting a claim and it picks up again when a denial letter is issued. But again, you're dependent on the language in your policy. Be aware of it. Make sure that you have vetted with your insurance attorney whether you still have time left to file suit. And if you do, you're probably coming close to that deadline. If it's a 1-year provision, make sure you reach out and file suit to protect your rights. Otherwise, you're going to be potentially barred forever. You don't want to give the insurance company more ammunition than it needs. And with that, that's the last slide. I thank you for your time, and I haven't looked at the chat yet to see if there's any questions. I'm happy to do that now though.
Okay, thank you everyone. That was a great presentation. Just a reminder to the audience, we are taking your questions in the chat. And while you get those in, we'll start with one of the first ones that came in for Bob. It's about two-factor authentication. Does adding the requirement of a text message with a code after entering your user ID and password to a login help protect our data or make it worse?
Well, it certainly helps protect your data. And it's something that we recommend that businesses everywhere give very, very strong consideration to. And that's based upon recommendations that have been made to us by cybersecurity professionals with whom we work. There's software available that facilitates it. And Kate mentioned the fact that the trend in the law is that businesses take reasonable measures in order to protect against unauthorized access to data. This is, in our view, one such reasonable measure. And absent some real good reason not to do it, businesses ought to do it.
I don't see any other questions in the chat, so just give each of you the opportunity for any final thoughts or any other topics that you maybe had to move through a little bit quickly that you wanted to elaborate on further.
I mean, I'll just add to what I said before and put it in some COVID context. Our slides basically recommend that you engage in a process. The law doesn't say you have to do X, Y specifically, but it does seem to require that you engage in a process to assess the risks and then figure out what to do in response to them to take reasonable measures. And once you do that, and you can make what they call an incident response plan, which I recommend you do, once you do that, you can't sit still. It's dynamic. You have to make sure that the measures that you institute are working. You have to make sure people are complying with them. And then you have to react to new developments. COVID is one such new development. It's a big one because of all the vulnerabilities we discussed. And I would urge everybody who's listening to take some very prompt action to make sure that you're doing what you need to do to minimize your risks.
Kate, Trevor, anything else?
Just briefly, I want to reiterate, I know I went through a lot of information in a relatively shorter amount of time. This is what I do, so I love to talk about it. I'm happy to, my contact information, call, email, I'm happy to take any questions offline or, later today or anytime really. Just happy to reach out.
Thank you.
I'll add on to what Bob said. I just have a couple of pretty basic and simple tips and steps that businesses can take to minimize the risk of a data breach. And the first is just to employ some basic employee training to teach your employees how to spot suspicious emails and remind them that while they're working from home and due to the uptick in these COVID scams, they should be extra vigilant before clicking on any links. One simple step that businesses can also take is to make sure that any external emails that are coming in are marked as such. So when I receive an email from anyone outside of our firm, the subject line has EXT, and it makes it really easy to see that the email is coming from someone that doesn't work with me, and it makes it easier to spot some of those phishing emails. In addition to that, make sure you have strong password policies, make sure your employees have to change their password every few months and use passwords of a certain length. Keep your antivirus software up to date. Utilize two-factor authentication, what one of our participants asked about earlier. Some of the simple cyber hygiene recommendations are simply don't collect information that you don't need and don't keep information that you no longer use. And the reason for this is because the more information you have, the greater the potential pool of individuals that could be impacted by a data breach, and the greater your potential liability is. So, just be mindful of that when you're requesting information from your customers.
Okay, great. Are there any online resources or tools maybe that an employer that does want to kind of educate and train their employees on what to look out for and what those typical kind of scams look like? Are there any online resources that you could recommend that they take a look at? I know internally we get those at the chamber, and I'm the person always kind of pushing those emails to everyone and telling them exactly what's wrong with it and why they shouldn't trust it. But is there any kind of resource out there that someone could take a look at to help their staff be kind of vigilant in that area?
So, I think it's a matter of degree. There's all sorts of online stuff about this. In fact, as I'm sitting here, I just got notifications from 3 experts in the cyberspace, technical experts, one of whom I know and is good. The solicitations are all out there. I'm just concerned about them. I don't, there are, and it's not a one size fit all situation, except on the basics that Kate just talked about. Mm-hmm. And how you implement those things are difficult. Yeah, look, there's certain things that you should train your employees to do, as Kate mentioned, but I don't know which online services to recommend. The odds are most of them are going to get most of it right most of the time, but yeah. I can't be sure that that all of them are going to do that.
Okay. So with that, we are going to wrap up. I want to once again thank our panelists, Bob, Kate, and Trevor, for being here today and talking about these really important topics that we need to always keep up to date on. I want to again thank the whole entire team at Archer and Griner for sponsoring and putting together this 6-week series. If you've missed any of our previous events, don't worry. They've all been recorded and they are all available on the on-demand section of the Chamber's website, so you can take a look back at what you may have missed. We will also send you a link to those recordings in email after the program. And you are welcome to come back next week and join us for the next session. It's next Thursday at 2 p.m. where we will hear from legal experts on recovery programs beyond the Paycheck Protection Program and COVID real estate tax appeals. Again, we were going to be sending out an email. It's going to have a quick survey. We would love to get your feedback on today's session. You'll also get the links to those recordings. And if you have any additional questions or would like to get in touch with our speakers, we will share their contact information with you as well. With that, I just want to thank our speakers again and wish everybody a great day. Thank you so much.
Thank you, Meredith.
Thank you.